Okay, it is a little bit after 7 o'clock, and welcome to week number 2 of constitutional law. And I'm Richard Wright. Many of you know me from previous classes, including present student on the call today. I know him and his twin brother. You take a you take a you take a Y and put an L instead. That's him. But yeah, so the Oyola brothers, I always think about that if you put an L in front of their last name, they'd be the Loyola brothers. And so, but yeah, but I know them pretty well, so it's good to have Joey in class again. Joel is finished, and so. It's good to have them again. So, well, okay, guys. As you know, this first week, you had, the first assignment done. It was due yesterday, actually, and this was your PowerPoint one, and I will be grading those by Friday. And one of the things that I always stress, and I say this over and over and over, you gotta pay attention to the module, and very important what I add to it, and then the rubrics. Because if you get those three things down, particularly the rubrics, then you'll maximize your grade in this course and head toward honor roll or dean's list. And that's what you want to do. I always remind my students, you don't come to my class to get an A or a B. You came here to get knowledge so that you can become a good criminal justice professional. And in the process of doing that, you do a good job at it and you'll get your A and B. So, but I never went to school for grades. I went to school for knowledge to be able to enhance my ability, which ultimately led to me becoming a lawyer. So I point to my students' excellence, and that's where we go. So let's start out by sharing the screen here. And here we go. As you can see, this is the spring term 2. Which started on Tuesday, Wednesday. Term 1 ended Tuesday, and we'll be going on until I think it's June 17th. I'll confirm that in a few minutes. So let's take a look at the assignments here. As you can see, this is from last week, and I got to grade these. I got 4 to grade from Monday, from last week. So I will grade those assignments. And then, so I've got 11 students in this class, so it's very manageable. And, so 4 submitted the assignments. And those of you who are behind, let's catch up. Let's get it going, because each day that you're late, you know the deal there. But I'm pretty relaxed when it comes to trying to help students. Remember that extenuating circumstances. Let me know if you got a problem. Text me, call me, email me any hour of the day except the 25th hour of the day. Don't ask me how to get a C in my class ever, because I don't answer that. All right, so that's what we had for last week. All right, so now this week we're going to be dealing with the U.S. Supreme Court and the exclusionary rule. I am going to talk about that, and then I'm going to send you some information either later today or either later in the week, because it's between 2 and 3 weeks 2 and 3, these assignments. But this is one of my favorite sessions, because I like the exclusionary rule, and you'll learn why in a few minutes. Those of you who are going to be law enforcement, You might not like the exclusionary rule, but you need to understand what it is so that you can do your job well. All right, so we're going to have that assignment, and then we're going to do the discussion. All right, so so the exclusionary rule. Okay, let's take a look at the calendar. And I always like the month view. As you can see what I said, we started here with the open house assignments. As you saw it here, both your initial post and discussion posts were due Saturday. Now, if you did your discussion post initially for Saturday and then you submitted your reply post Sunday, you still got credit for it. But if you did it after that, you didn't. But if you did both of them on the 15th, you didn't get credit for it. So, but that's the way I roll. And then your written assignments, as I was talking about, that were completed yesterday, just your key phrase and then your written assignment. Now, today is a live lecture. Your initial posts now, from this point on, are no longer due on Saturdays, but they're due on Tuesdays. As you can see, if you scroll down the calendar, you'll see each week. And then your reply post is due on the 21st. Those are Saturdays, with the exception of when we get to the last week. So let's take a look at that. Very close by, you can see that the course ends the 17th. That's what I said earlier. That's the last day of class. And then your posts, your reply post will be due on that day. But you got a little ways, but it'll come fast, trust me, before you know it. So I'll be glad when we get here, because then after that, I got 2 whole weeks off before we get to. With T1 and T2, you don't get any time off because you start the next day. So, okay, so now please be sure to understand, as a student asked me already, and I told him no way. After the last day of class, I cannot accept assignments. You heard me talking about that last week as well. Students still always trying to do it, but if you get an incomplete, appropriately granted, then I'm pretty fair with communicating with students. I get to know my students pretty well. My students become my friends. Even if they don't do well, they still become my friends. So my job is to point you in the right direction, and your job is to pick my brain if you need to, okay? So, all right, so here's week 2 announcement. Let's move this for a minute because it's a little bit in the way. Second week, 14th Amendment and the exclusionary rule. Chapter 7 of the text, and the PowerPoints were given to you already. And then we're going to deal with teaching the forgotten 14th Amendment and the Constitution of Memory, exclusionary rule, 14th Amendment, research starter, and we'll talk about that. So, and we'll deal with all of that stuff today. The 14th Amendment, and then the exclusionary rule, and the knowledge check. Remember the written assignment that is this week is the U.S. Supreme Court and the exclusionary rule, which is due Sunday. And then your discussion assignment, exclusionary rule, is going to be due again. Tomorrow, your initial post. Saturday, your reply post. And remember, start strong and finish strong. I encourage you. But most of all, pay attention to adversity as a springboard to success. Many of you already know my story in there. I've given a copy of that to you in here. There it is right there. And you feel free to click on it anytime. Share it with students as well, friends, anybody, because it's something to let you know that it doesn't matter where you start. It doesn't matter what obstacles you run across. You will be able to still navigate. And so Remember, we're a team here. I'm the coach and you're the players, and I'm teaching you how to execute plays. So let's get into the module, the 14th Amendment and the exclusionary rule. So here's your written assignment. Let's go over that. All right, let's put that back up there. So overview is procedural due process is about fundamental fairness. I talked about this last week. And the legal procedures that are followed. And what it does here is part of the procedural due process is to make sure that when you are a law enforcement officer exercising your authority, that you do follow the law. Otherwise, the exclusionary rule will be used by the defense attorney. I used it a lot because I was a top-notch criminal defense lawyer. But I was also on the other side for a while. I was a police officer. But I totally appreciate, and I have many of my friends that became clients actually that were police officers who used to talk about the exclusionary rule until they became the subject of an investigation and they hired me as their lawyer. I says, now we're going to use a motion to suppress and the exclusionary rule. Okay, that's good, good. But it's basically, to be honest with you, a way of teaching law enforcement officers to abide by the constitutional rights that are afforded individual under the United States Constitution. So we're going to deal in this written assignment with 2 U.S. Supreme Court cases and discuss how the exclusionary rule was applied. That's what you're going to do in your written assignment. Now, Hudson versus Michigan and Missouri versus McNeely. Now, before I get to the requirements of the assignment, please do me a favor. And when you cite these cases, cite the full case. Hudson versus Michigan is starts out with a number. It says US in between, and then it has a second number, and in parentheses it has the year. And at some point today you'll see exactly what I'm talking about. But it's very important. That's how I teach you. That's my requirement, because when you're in my class you go by the rules that I give you, and that's part of, as I was telling a student earlier today at the award ceremony, that my role was to teach you how to follow instructions, because you're going to do well in life when you do that. So anyway, you click on these and you can get these 2 cases. For example, let me see if we click on this one. Okay, now here's the deal. Do not use oyez. I don't want you to use oyez. I want you to use the actual case citation, which is not here. Okay, I don't want you to use this, but this tells a little bit about the case itself. All right, I don't want you to use that as a 5-4 decision. When a case is 5-4, what you should be aware is that those who are not highlighted here, and 2 of them have passed away, and one's about to retire, is Stevens, Ginsburg, John Paul Stevens, who is a graduate of my alma mater, Northwestern Law School, and I met him, was a dissenter in this case, as well as Salter, and then Ruth Bader, notorious RBG, as some people called her. And then Stephen Breyer, as you know, he's retiring. And I'm excited about Justice Ketanji Brown Jackson, the first African-American female to be on the bench. So, and Salter, I think one of these, you have Sotomayor is on there, and then there's somebody else I'm missing. But anyway, the fact of the matter is when this decision was issued, you will discover quite well and quickly Let me see. I got a second here. I have some notes here. Let me pull them up for myself, and then I'll tell you what they say. Give me a minute or so. It is, okay. Okay, here it is coming up. Hudson v. Michigan. Okay, here it is. Hudson v. Michigan is 547 U.S. 586. Okay, 547 U.S. 586, and in parentheses, you should have 2006 because it's a 2006 case, as you see that already up here. Okay, so that's how I want you to cite that case, and it applies the knock and announce rule and that kind of thing. All right, so anyway, you can find that there, and then you can also do some further research, and you can get it there. The same thing with Missouri versus McNeely. And Missouri versus McNeely, I have it here too. It is, yes, here it is. All right. Okay. Here it is. Missouri versus McNeely. The appropriate for that is 569 U.S. 141, and that was a 2013 case. Okay. And this, I think this one was this one, I think this one was it 5-4 or 6-3? I think it was. Yeah, it was 5-4 also. And you can see here now um, the dissenters here were Justice Roberts, Clarence Thomas, Stephen Breyer, and Alito. Okay, and Justice Sotomayor, she's the lone Hispanic justice, and she wrote the opinion. And this has to do with blood alcohol tests. It's a very interesting case. You get a chance to read it. All right. So anyway, those are the. Let me close that out. All right. So those are the two cases that you're going to review. Now, develop a 3 to 5 page. Did you hear me say 3? I didn't say 2. I didn't say 2.5, 2 3/4. I said 3. 3. I have to drum that in because you're going to lose points if you don't have a 3-page paper, APA style, double space, citations in the body, references in the end with the appropriate citations. And I already told you how to cite the case. Now, when you cite these two cases that I mentioned, by the way, you don't have to cite each time after the first time. Now, I'm not talking about the caption either. I'm talking about in the body of your paper. Make sure that you appropriately do it the first time, and then after that, you don't have to do it exactly fully. But I don't want to use oh yes, please don't. All right, because that's just a summary of the case. So summarize the facts of each case. Explain how the exclusionary rule was applied in these instances. Identify how any of the exceptions may have applied to either case. All right. And cite credible sources in APA format, including a reference page. So you're going to have to do some research. All right. And double space, cover page, double space, cover page, double space cover page. I'm not trying to be funny. I'm just telling you. I know every time, and there's going to be people who cite oyes, and I know that they didn't listen to the lecture. All right. So if you need help with any of that, you can do research with the Justice Studies librarian if you need help. That's Dennis Johnson. I mentioned that last week. But there are sources. I showed you how to find the sources. Then APA is important, very important. All right, so now let's look at the rubric. Now, because as I said again, if you don't have citations in the body of the paper, and I'm not really talking about the appropriate citation, but citations. Citations provide support to your statements in the paper. And so if you don't have citations, it's going to be considered as incomplete or incorrect, incomplete or incorrect, incomplete or incorrect. No credible sources provided and no reference page. You're going to lose. You're going to end up in this column. Professional. So now notice this. Some students say, oh, I provided references, but I didn't provide credible sources. No, it says no credible sources are provided and or no references is included. So you got to have citations and references because it's not APA otherwise. All right, I can't put you in if you don't have APA. You can't fit in any of these. And so a student one time says, you mean I lose this many points? It's because the rubric is balanced to try to force you to understand the seriousness of not providing credible sources. Why we do that? Remember the academic integrity video that we talked about. And it's so, so, so important. Trust me, I had a student who posted on Facebook that he got a job because he mentioned how he understood APA, and I was fortunate that he in the Facebook mentioned in the interview he mentioned that I taught him that. I teach my students that, and don't cast it away. It's very important. Trust me. And then notice this: if you have 2 pages, you're going to lose. You're going to be over here. Professional language is not used in the 3 to 5, or it does not meet the 3-page minimum. So you're going to end up over here. So that's why you could lose points. It's 2 little things that you can miss. Not enough pages, and also not satisfying the credible sources APA style. Then you're going to lose points. You won't get all the way over here if you cite the case improperly. But I showed you and told you how to do that. And that's it. So this is what I tell you. Pretend this doesn't even exist. So these are, you want to deal with this with Hudson versus Michigan, McNeely, Missouri versus McNeely. And then you want to explain the exclusionary rule and how it works. I will be talking about that during my lecture tonight. Outstanding identification of any exceptions to the exclusionary rule. So there are some exceptions to the exclusionary rule. We'll discuss that. Credible sources are cited in APA format, including reference with no errors in that. So reference page with no errors. So if you don't cite the case appropriately, you're going to probably get over here or here, depending on what's there. And the key thing is that it's important for you to want to be over here, because this is how I teach. All right, I think that's pretty clear. So let's move on. Let's get out of there. All right, so now let's go to the discussion post. So the exclusionary rule discussion assignment, you're going to discuss the exclusionary rule to a real world scenario. Here it is right here. I'm not going to read it. Okay. Well, actually, I will read it. This is a fun one to me. You're a homicide detective. You and another detective interview a homicide suspect. His name is John Smith at his residence. He invited you in, and an interview is taking place in the living room. Now, in that interview, by the way, if you're in an interview, do you have to give the Miranda warnings? Yes or no? You can type in the chat. I'll see it. If it's an interview, do you have to give Miranda warnings? Well, the answer is it depends. It depends if the person is in custody or is not free to go, as I remind students. So in this case so far, it doesn't give us any indication that he's in custody. So he invites you into his living room next to the front door. And while you're there, you got to go to the bathroom. So he says, go through the kitchen and down the hallway and tells you where the bathroom is. Now, you decide with your nosy self to have, because you have a habit of opening refrigerators and freezer doors and looking inside. In this instance, when you open the freezer door, you are startled by the presence of a severed head. John Smith could have been, what's his name? Jeffrey Dahmer or John Wayne Gacy, but Jeffrey Dahmer especially. A severed head, which is inside a plastic bag. So you go and you tell your partner, get him. John puts up a fight, but he's taken into custody now. Okay. Yeah. Yeah. So now that he's in custody, then before you question him, then you give him Mirandize. Oh, okay. No problem. No problem. So, so the severed head is later positively identified as a recent homicide victim. Now, even before you get into studying, does it sound like this detective did something good or bad in finding this head? Bad, good. Well, the good part is about he discovered it. The bad part, though, is when you study exclusionary rule, you're going to discover that it doesn't fit any of the exceptions and it's not going to be able to be used. You'll see that in a little bit. I was just tipping you off to that. So in your initial post, explain the exclusionary rule, discuss if it applies into this scenario. I told you it does. That's a little biscuit. That's a good thing about coming to class, live lectures. And then if the exclusionary rule applies, what are the potential ramifications? And I already told you this, and I'll say it again. I'll be doing it during the lecture. If the exclusionary rule applies, it's excluded. It's called the exclusionary rule for a reason. The name speaks what happens. It's excluded and cannot be used. And then support your comments with sound legal argument. And then reply to one other post at least. Okay. All right. So this is my favorite post. My favorite post. Okay. So then your live classroom submission, which you'll be able to give the keyword, which, by the way, you should begin to focus in your mind what the key word or phrase is already. Don't say anything, but I'm going to ask. But anyway, I'm laughing. Um, so we're going to then provide you with the link here after we finish the recording, and it'll be the one that recorded lecture. but I'll also email it to you as well. So I'll be removing this, because if I clicked on this, it would mess us up, because it would bring us right back here, and then we'd have double sound, and it'll be messed up. All right, it'd be like echoey. All right, so let's talk about the 14th Amendment. Let's talk about the exclusionary rule and the exceptions to the exclusionary rule. All right. So let's take a look at the 14th Amendment. So now you should be aware and understand that the 14th Amendment, which came out in 1868, was passed after the Civil War and during the Reconstruction to establish rights for African Americans, also known as Black Americans, Negroes, back in those days. Civil and Legal Rights section, Section 1, explains most commonly cited where it arises. So Section 1, there are other sections, but Section 1 is the one that we're going to concentrate on. All right. It says all persons born or naturalized. So what does that mean? If you're born in the United States, or either you become naturalized through immigration and the process, and subject to the jurisdiction, are citizens of the United States and of the state where they reside. Not where they were born, the state where they reside. So you could reside here in Illinois and then move to Florida. And so that's the state where you reside, where your residence. So no state shall make or enforce any law which abridges the privileges and immunities of the citizens or the rights of the Constitution, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction equal protection of the laws. Now, what all that means basically is this, is that everybody is entitled to the protection of the 14th Amendment. Now, in addition to what I told you earlier about the Section 2 aspects, Section 1 just simply, if you notice, it applies the first 10 amendments, called the Bill of Rights, to the states, Prior to that, prior to 1868, the Bill of Rights did not apply to the states, but applied only to the federal government. Okay, so we're in a time now, but that's why we have it. So we're not even going to get into these, to the other aspects of it. All right. So now, what are the citizens' rights? I already kind of told you. And that means that you're entitled to all the rights and privileges if you are a naturalized or a person born in, and the state where you reside, that's where you have those rights. Now, let's say, for example, if you don't reside in a state and you commit a crime in another state, okay, you go to another state and commit a crime. In that instance, then, it still applies, because the state itself cannot, based on the privileges and immunities, take those away from any person from state to state. As you see in the Twining case, privileges or immunities, the right to pass freely from state to state. And so the point of the matter is, so that's why I said what I just said a few minutes ago. Okay. Now let's go to due process again as we conclude this section, so you understand, but I think you kind of got it already, is that, again, the states cannot lock you up, take your property, deprive you of your freedom within a jurisdiction without doing it equally, not based on your race, your sex, not based on what you look like, You know, I tell my law enforcement people, what does a criminal look like? And, you know, they can, you can be surprised. They, but I know what we mean when we have opportunities to see individuals that appear to be criminals. But don't typecast somebody. Don't stereotype people. And whatever you do not pick on a person because of their race or national origin, assuming that that person is African American and that he's a criminal, or a person is Hispanic or either any other minority, that they are criminals. That's bad news, guys. You don't do that because the due process clause says you cannot do that, and equal protection is there. So I've said that, and I'm gonna move on. So no state can can deny these rights, which originally came from the Fifth Amendment. And as I said, the 14th Amendment applies it to the states. And therefore, in criminal cases, no state can deny individuals, even the Napoleonic Code state, which is Louisiana. Most our jurisdictions have law based on Britain, but the Napoleonic Code is based upon France. So the idea of the 14th Amendment is fundamental fairness. Establishes legal procedures that are established in each state that are different. And we talked about that last week. And the state typically complies with those fairness and allows individuals the opportunity to confront. Remember the confrontation issue we talked about last week, and cross-examination, doing what we call disclosure or discovery to be able to obtain the evidence against them so that they can prepare an adequate defense, availability of counsel, and so forth, right, to a speedy trial, among other things. All right. So what we're going to do now is we're going to move and apply this due process concept that we have been talking about thus far to protect the rights of people and to determine that a person that's innocent should not be convicted. Now, listen to me good. If a person commits, okay, like that person in that with that refrigerator, he committed a crime, definitely, but he's protected from by the Constitution. And remember, search and seizure, if you get into the Fourth Amendment, which we will, it says, and we'll be talking about that more next week, that if you see something improperly, it could be dismissed from the case by a filing of a motion to suppress by a defense attorney, which I did a lot of those, because you violated the Fourth Amendment, probably in the case of the guy with the head, and that you had no business going in the refrigerator. Let's, you know, that kind of thing. Let's say, for example, if he said you want something cold to drink, and he says go into the refrigerator, and you go in the refrigerator, and then you see it, without obtaining a warrant, you can obtain that because there's a exception, which you may have heard of already, called plain view, because it would be in plain view. Does that make sense? I think it does. It does. So the point of the matter is that you were given permission, but in this case, he was not. All right. So your palate should be wetted a little bit on that issue. All right. Let's get to the exclusionary rule itself. All right. So this gentleman is under arrest, as you can see. So he's at this point, he's got handcuffs on him. That means he's not free to go. that means also you need to Mirandize him if you're going to ask questions. All right. So now let's talk about what law enforcement has to do by losing this little paragraph. You're a law enforcement assigned to a community policing detail. All right, which your brother would know all about that, Joey, because that's what he does, and allows you to become familiar with the residents, so you get to know them. So because of the trust you build, it's common for citizens to leave anonymous tips. All right. So David Brown was reportedly a cocaine dealer, and his address was given. All right. And you suspected that David is selling cocaine, but have not been able to prove it. However, you think that the anonymous tip is exactly what you needed to finally search David's house. The next day, you and a couple other patrol officers knock on David's door. He answers and he doesn't allow you to search. That's one of the exceptions to get a warrant. Consent. Consent. We'll be talking about that coming up. With the tip in mind, the officers go into residence and the search, they find cocaine. This is a debacle. This is messed up. It says, although it is well established that information obtained from an anonymous tipster is questionable, at best you believe you're on solid ground. Can the evidence be used against David? No. 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 No, 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 no. And you're going to learn why and now. So you learn about procedural due process. So when the defendant is accused of crime, they have the right to discover, through the discovery process, the evidence that is held as to substantiate the charges. The evidence must be legally obtained. Legally obtained. The exclusionary rule forbids illegally seized evidence from being used at trial, with a few exceptions. And we're going to talk about the rule in a minute and some of these exceptions. All right. So the exclusionary rule originated in 1914, and then moving forward, Mapp versus Ohio, we'll talk about both of those cases. So let's talk about the Weeks case. Now, in the Weeks case, if you cite that, you're going to have the full court citation, which my recollection from last time I taught this, which was last term, just scrolling down for a minute, I think they put it at the bottom. They did. There it is right there. And Mapp versus Ohio. And then Miranda. And then, so they got them all down here, so you can find them there. So I won't have to give them to you. So let's talk about Weeks for a minute here. So the Supreme Court acknowledged that the exclusionary rule in the Weeks case, and this is what happened, is that this fella, Weeks, was suspected of illegally mailing coupons for the lottery, and he was arrested without a warrant at his job, and police officers went to his residence, and a neighbor told the police where they could find a key to enter. And they seized some evidence, books, papers, so forth and so on, and turned them over to the U.S. Marshal. So later that same day, police returned to the residence with the U.S. Marshal, conducted another warrantless search and removed additional evidence. He was prosecuted because the fraudulent lottery tickets were sent across state lines. So before trial, he asked for his property back, and the court said no, and he was convicted, fined, and imprisoned. So it went all the way to the United States Supreme Court, and in the U.S., Weeks versus U.S., the Supreme Court made a decision to examine if the search of Fremont's house violated the 14th Amendment, and if so, should the evidence have been permitted at trial? And the answer is right here. The answer is yes, they did violate it. The court said the search was unlawful. If you listen to the facts, it's what you learn about warrants and so forth. You can't just do that. That's a violation of the Constitution of the United States. We do that in Russia, but not here. If so, the evidence would have been permitted at trial. So the court said it was definitely unlawful, and that the seized evidence, no matter how good it could be excluded. And the court applied to the federal rule to the federal authorities. And in contrast, the papers were not seized by police under any claim of federal authority. Therefore, the exclusionary rule didn't apply to state officers. This would change in the case I'm getting ready to talk about now. Okay. Remember, it didn't apply in terms of state, but it applied to federal. All right. So now let's get to Mapp versus Ohio. Mapp versus Ohio, Dola Ray Mapp was a bomber, a suspected bomber in Ohio, and she was arrested. But she was arrested for possession of pornographic stuff. She told the police, "You can't come in." She told her attorney, who got there. The officers returned 3 hours later and forced entry to the residence. That sounds like some Gestapo stuff to me. Officers would not allow her attorney to even get in. And so what happened is that the officers, she wanted to see the search warrant, which she had a right to see. An officer held up an alleged search warrant, which she snatched from his hand and tried to conceal it on her person. Officers struggled with her, retrieved the warrant, and handcuffed her. The officers continued to search throughout the residence, and they found everything they wanted, and no suspected bomber was found. Well, at trial, the court said the police were unable to produce a warrant. You know why? Because that paper was not a warrant. But she was still convicted anyway. So upon appeal, the Ohio Supreme Court said there is a considerable doubt as to whether there was ever any warrant for the search of the defendant's home. However, this is what the Ohio Supreme Court said. However, since the evidence was not taken directly from her by using brutal or physical force, it could be used against her. So the court believed that a case of Wolf versus Colorado, a 49 case, which permitted the admissibility of evidence at trial, even if it was seized unlawfully or without authority. Remember, this is before we get to the case of the state of the exclusionary rule. But see, in the 49 case, the Supreme Court analyzed if states were required to exclude illegally seized evidence under 14th Amendment and the 14th Amendment due process. The court said the exclusion of evidence may have been an effective way to deter unreasonable searches. Other methods could also be effective, such as civil remedies and so forth. And so they said it's okay. So she was convicted and she lost on appeal. So now she goes all the way to the last court, which is U.S. Supreme Court. The Supreme Court granted certiorari. When you hear certiorari, what that means is that's the way that Supreme Court says we agree to hear. They don't have to hear all cases, okay? But generally, when there's a big issue involved, they generally will hear it, like they're getting ready to do with this abortion case, and already have done what they're going to do. In a unanimous decision, when you hear that now, when you hear that, that means 9-0 generally. the Supreme Court said that the defendant, Dola Ray, that her Fourth Amendment rights against unreasonable search and seizures were blatantly violated. I had blatantly in there. Therefore, the evidence should not be used against her at trial. And the court reversed and sent back to the state courts. When they reverse and remand, what that means is they're saying, no, you all messed up. Now, let's try this again. So the Dola Ray map case applied the exclusionary rule to states now. Remember, earlier weeks was to the federal government, which is applied many times to exclude unlawfully seized evidence. And then they referred to the Miranda case, which I don't think that's correct. I believe the Miranda versus Arizona was a 1966 case. And I know that well because of my former professor. Those of you who had criminal law with me know I know a lot about that one because my professor was not happy with it. Anyway, it applied the exclusionary rule to improperly obtained confessions. That's when we had the Miranda warnings. So the exclusionary rule helps prevent law enforcement from being lawbreakers, violating the constitutional rights of individuals. Law enforcement should lead by example. So if you're going to prosecute someone, if you're going to arrest them, dot your I's and cross your T's. Okay. So now, as we conclude this big issue, let's talk about what the fruit of poisonous tree doctrine is. So now, what that means, based on what you've already learned so far, is that any evidence, as we already learned, obtained from unlawfully seized cannot be used at trial. This is the reason why is because it's the fruit of the poisonous tree. It established in the Silverthorne lumber case in 1920. In this case, evidence was obtained pursuant to an unconstitutional search and seizure. Any evidence obtained from the unconstitutional search or seizure could not be introduced in court. So the exclusionary rule extends to evidence unlawfully seized. Any fruit of a crime. So any evidence of a crime obtained from an unlawful search or seizure cannot be used in criminal proceedings. So now you know why that head could not be used. Okay? And then it continues that therefore if police violate the defendant's Fifth Amendment right to silence, that's when we get to Miranda, or Sixth Amendment right to an attorney when we get to Gideon versus Wainwright, during a custodial interrogation also found in the Miranda case, you have a right to an attorney, and any information obtained during that interrogation that leads to additional evidence it can't be used because it's the fruit of the violation of the Constitution, which is the fruit of the poisonous tree doctrine. So now you know the answer about David Brown up here, and you also know the answer to the discussion post as well. All right, so we conclude by saying that although the exclusionary rule is a powerful deterrent to unlawful policing tactics, it serves as a check and balance between law enforcement and the court. And then there's some exceptions that we'll discuss next week, okay? And you'll learn about the exceptions next week. Don't worry about that at this point. Map versus Ohio, they're the original citation that I'm looking for if you cite these cases. All right, so anyway, this I'm just going to just show you in a minute. This is, again, where they have some exceptions that they give you, but don't worry so much about it, and you'll look at these facts, all right? But these are a few things that we're going to get more into that next week, but that's just something you can get into. And then you can go over and you can study all of that by going through this little practicing. And so what I wanted to stop there is that when you listen to this is what I want you to listen to, because you'll listen to it. And I have my headset on, but you listen to it, it will give you 4 exceptions that you can be aware of. Even though I said it, we're going to be covering it next week, but these are just to make you aware of the exceptions. But we're going to get more in detail in the 4th Amendment. Okay. But just to show you just quickly what those 4 are, I'm going to skip over the thing. Okay. Here they are: the good faith exception, independent source doctrine, inevitable discovery, and attenuation source. So I'm not going to go over those, but you can take a look at those if you have any questions. And it gives cases also as well. Okay. And then there's a knowledge check too that you can do at the end. And if you go over that, you do these, but let's just do one here. Do a couple here. The right to pass freely from state to state to petition Congress for redress of grievances and the right to vote are examples of what? 5th Amendment, procedural due process, privileges or immunities, or substantive due process. So is it A, B, C, or D? Which one? Okay, I know you're having trouble with the chat, so I'll type it. It's this one. Privileges and immunities. We talked about that earlier. Okay, I think, let's go back. I want to go back a minute. I think you said privileges or immunity. Yeah, you said B. Okay, so you got it. All right. Okay, so I got to do that. Privileges and immunities. Okay, let's do one more, then we'll call it a day. Okay. What is the landmark case that first established the exclusionary rule? Was it Miranda? Was it Weeks? Was it Gideon? Or was it Arizona versus Gant? Was it A, B, C, or D? Which first established it? A, B, C, or D? You think D? Wrong answer. It's Weeks. Remember Weeks? It was a 1914 case. We didn't even talk about the last one. You'll see later. So anyway, that's why you want to, go over these. In this course, because of the fact you don't have a quiz or a test, a lot of students try to ignore stuff like this, but don't, because you want to get this right. Why do you want to get it right? Because you're going to be a professional one day, and you're going to need to know this. You're going to need to know this. Gant, Arizona versus Gant permits the search of an automobile incident to an arrest for evidence. We'll talk about that later, but not today. All right. Let's do one more because we did start a little late. Let's go. Okay. Now, the exclusionary rule This is the last one we're going to do. The exclusionary rule prohibits any evidence obtained from unlawfully seized evidence from being used at a trial. This is known as what? A. Take that S off. It's fruit, not S. Yeah. Okay. But you got the right one. Yeah. Yeah, that's correct. All right. Stare decisis. I didn't mention that, but it says stare decisis means let the decision stand, which is a judicial doctrine that relies upon previous decisions on similar cases. That's how cases are decided. So the correct answer is fruit of the poisonous tree. Voir dire is part of jury selection. A motion hearing examines the evidence. Stare decisis means let the decision stand. So that's not it. So, okay. All right. So that's it for me. Question? Any questions? Okay. How about this? What do you think? Go give an idea about the key phrase or word. You can type it in the chat box. Yep. No, you got it first. You got it first. How many times did I say exclusionary rule? I know you lost count. And every time I said it, I kind of emphasized it, didn't I? And I was laughing because I said you could tell what the key phrase is going to be. Okay. Exclusionary rule. That the lecture itself was all about that anyway. Okay. Thank you, Joey, and enjoy the rest of your week. Stay safe and keep doing what you're doing. Get those assignments in, though. Let's, guys, get all your assignments in so we can move you forward. All right, so I'm going to say good night at this time, and I will see you guys next Monday at 7 o'clock p.m. Central Standard Time. All right, take care. Good night.